So today we are going to cover most of the consideration, except for promissory estoppel. That requires a whole separate session. So that's why promissory estoppel is not included in our today's lecture, but we are going to cover most of the consideration today, or at least we will try to do that. Let me put all of you on mute status. Okay. All right. Okay, so consideration, another important and in fact extremely important element of contract. So I'll start this lecture by giving you an example so that you understand what consideration is. So my example is that if I promise to drive you to Oxford and you promise to pay me £50, so those are our exchange of promises. And your promise to pay me £50 involves both a benefit to me and a detriment to you. It will benefit me and it will be a detriment to you, since you will lose that money after you have paid me. So these are the two angles on consideration. Just a second. Okay. So these are the two angles on consideration, detriment and benefit. So consideration is always a benefit to one party and a detriment to the other. And this is given in return for my promise to drive you, right? And that's the second side of the contract. So one side of the contract is that you promise to pay me £50, and that is one side of the contract. And the second side of the contract is that I promise to drive you, right? So all bilateral contracts have two sides, and all considerations have two angles. Conversely, my promise to drive you is both a benefit to you and a detriment to me, and that is given in return for your promise to pay me. So the definition of consideration was derived from the case Curie versus Nisa, and the definition that was derived was by Lush, and the definition was: a valuable consideration in the sense of the law may consist either in some right, interest, profit, or benefit accruing to the party, or some forbearance, detriment, loss, or responsibility given, suffered, or undertaken by the other. So if you look at the example again, you will see that it fits this definition. There is a benefit to one party and a detriment to the other, and looking at the other side of the contract, there is a detriment to the other party and benefit to the other party. Okay. So is this example clear to everybody? So you need to understand that there are separate considerations on each side of the contract. But what counts as consideration in any given contractual dispute, when a dispute arises, that will depend on which obligation on which side of the contract the court is asked to look at, or the court is asked to enforce. And this will obviously depend on who is suing whom. So in every bilateral contract, there are two considerations, but the consideration under question depends on who is suing whom or which side is enforcing the contract. So now that we know what consideration is, we need to understand that consideration needs to be sufficient, but it does not need to be adequate. In other words, the benefit or detriment need not be equivalent in value to that which received in return. So in the earlier example, for example, let's go back and see. So I promise to drive you to Oxford, but in return, you promise to pay me maybe £10, let's say, instead of 50, or let's say £1. You promise to pay me £1. Now that £1 is of course not the actual value of me driving you to Oxford, but by law I am allowed to request anything that I want as consideration. So this means that it does not need to be adequate or equivalent to the value, but it needs to be sufficient. And I am the one who decides that it is, whether it is sufficient or not. So let's look at a case, a very famous case, Chappell and Company versus Nestle. The facts of the case are that defendants, they ran a promotional offer that public could receive music record by sending off 3 wrappers from defendants' chocolate bars, plus a postal order for 1 shilling and 6 pence, about around 7.5 pence. So defendants manufactured the records for this purpose. The issue was whether the wrappers were part of the consideration. So that was the issue that was raised in this case. And the majority held that wrappers were part of the consideration, right? They had trivial economic value, and they were, of course, thrown away by defendants when they received the wrappers. But they were considered as part of the consideration. So in this case, it did not matter that the wrappers in themselves were worth very little and did not equal the market value of the record. Even if you add the postal order of 7.5 pence, even then they were not equal to the market value of the record. But Nestle were free to request whatever they wanted, right? And in this case, they obviously hope to benefit economically from the arrangement out of increased sales of chocolate. So there may be some other benefits. So in our earlier example, if I request you to pay me £1 for me to drive you to Oxford, I may have some other benefits in mind. I may run a cab business, and I am hoping to benefit. I am hoping that you will increase my business, or you will refer your friends to me. So I may have some other benefits in mind. So that £1 would be considered a sufficient consideration, although it is not of equivalent value. Okay. So another important point is that you might consider something as sufficient consideration, but it may not be legally sufficient. So we are going to look at many cases today and to see different situations where courts held whether the consideration was legally sufficient or not. So there are going to be many instances here in the cases where you would think that the consideration is sufficient, but we need to understand that we need to know whether it is legally sufficient or not. So let's look at our next case, which is White versus Blewett. So, and this case considers forbearance from legal activity. So courts, in this case, courts questioned whether forbearance from legal activity was a good consideration or not. In other words, was it legally sufficient or not? So the facts of the case are the defendant owed his father money and had given him a promissory note. And then the plaintiff, the father's executor, sued for the money. The defendant claimed that his father had promised to write off the debt if he stopped complaining about the father's distribution of assets. So the son claimed that this was the consideration that he had offered, that he would stop complaining about father's distribution of his assets, and that is what his father had requested as consideration. And the issue was, is forbearance from permissible legal conduct? Of course, complaining is a permissible legal conduct. We all do that. Whether it was sufficient consideration to create an enforceable contract. So it was held that defendant had not provided consideration. It is interesting to see what the court had decided. They said that he had no legal right that he had given up. So complaining was an intangible benefit, and it was not a legal right. It was not like he had given up some right. Otherwise, it would have been considered as consideration. So it appears that giving up rights, from this judgment, it appears that giving up rights can be legally sufficient benefit, but giving up something you had no right to do in the first place cannot. Anyone see any problem here in this case? If you consider this, that the courts decided that he had not given up a right. Anyone? Yes, Jennifer, courts is making a judgment as to what is sufficient consideration, and they decided that it was giving up a right would have been a consideration, but he had given up no legal right. Okay, so let me explain it to you. To me, it seems strange to say that a person has no right to complain, actually. So, of course, that was back in 1852, and the free speech has come a long way since 1852. And perhaps it would be more appropriate today to say that the son did give up a right. He did have a right to say whatever he wanted to say. And he had the freedom to complain. So by refraining from complaint, he suffered a detriment in return for the promise. Do you agree? Okay. Yeah. So, but that was long time ago in 1853. So after that, there has been many changes with regard to free speech. So if this case was decided today, I assume the outcome would have been different. At about the same time period, another case was decided in the U.S., and it is Hammer versus Sidway. Now you will see that it is an alternative view. Of course, as I always say, that cases from other jurisdictions such as the United States are not binding in UK, but of course they tell us how a court may approach that issue. So in that, it is an American case. So you have to keep in mind it did not overrule White versus Lewis. Here, the plaintiff was promised $5,000 by his uncle if he refrained from drinking liquor, using tobacco, swearing, and playing cards or billiards for money until he should become 21 years of age. Now, the issue again is forbearance from permissible legal conduct sufficient consideration to create an enforceable contract? Here, the court held that promise was enforceable as the plaintiff provided consideration by restricting his lawful activity. He had all the right to use tobacco, to use liquor, to swear, to play cards. So he had given up those rights. So court decided that it was a good consideration since he had given up his since he has restricted his lawful activity. Now let's look at another situation when one party has an existing obligation towards another, to the second party or to the third party. So we are going to see whether performing existing duties can suffice as consideration or not. It depends on the circumstances, as we will see in the case law that we are going to discuss in a few minutes, because duties may exist for different reasons, such as public duties, or it can be contractual obligation. So according to the situation and circumstances, the answer differs. So the simple issue at the heart of this question is whether doing something you are already obliged to do can legally count as a benefit or detriment. Okay, so we're going to look at three situations: existing non-contractual obligations, in other words, public duties; existing contractual obligations, so between two parties; existing contractual obligations owed to a third party. Okay, so let's first of all, let's look at public duty cases. General rule. General rule is that performance of an existing non-contractual duty generally cannot in itself form good consideration. Our main case law here is Collins versus Godfroy. Here, the defendant had promised the plaintiff some money to testify in court. However, the plaintiff was already supposed to testify in court. So the issue was, can performing a legal duty, that plaintiff was already under obligation to do that legal duty, but performing a legal duty can be sufficient consideration or not. So here, what did the court have? They held there is clearly a public policy issue, but the agreement was unenforceable as there had been no consideration. The plaintiff was already under public, had that public duty. He was obliged to do that duty already, so there was no consideration from his side. So the promise to pay a witness in this case, who was already under a public duty to give evidence, lacked consideration. Okay. Here you can see that the witness actually did nothing above his duty. So he had nothing, he did nothing above and beyond his duty. He just performed the legal duty that he was under. So there was no consideration flowing from the plaintiff's side. Interestingly, in another case, same situation, it is a public duty case, but the outcome was different here. So the case is Glassbrook Brothers versus Glamorgan. Here, the defendants, they were an owner of a coal mine, and there was a strike going on. So they wanted the police to offer a visiting patrol services, right? But then the defendants were concerned about site safety and decided they wanted a stationary on-site presence. So police was offering them a patrol service that we'll just come around and we'll see if everything is okay. But the defendant said that no, we want you to have a stationary on-site presence. And they agreed to pay the police for this service. So later on, of course, the defendant refused to pay. That's why this case went to the courts. And the ground that the defendant used was that the police was performing their duty to keep the peace. They already have this obligation. They have this public duty. So it was held that police had gone beyond their existing duties. So on the facts of this case, it was the court held that the police had gone beyond this duty by providing more protection than they were obliged to do. They were just obliged to give them a patrol service, but they went above and beyond that to give them stationary on-site presence. And by exceeding their public duty, the police did something they were not obliged to do. So provided a benefit to the defendant and incurred a detriment. So do you see why this case is different from Collins versus Godfroy? Okay. So if I ask you what is the difference between these two cases, what is going to be your one-line answer? Excellent, Jennifer. Very good, Yesha. Beyond the legal duty. They perform something beyond the legal duty. Excellent, Rahim. Very good. All right. Now let's look at another case, which is Ward versus Bayham. So despite the, if you look at the facts of this case, let's look at the facts together. The plaintiff, the mother of an illegitimate child, agreed to look after her child well and to allow the child to decide who she wished to live with. In return, the defendant, the father, promised to pay maintenance. And then the defendant ceased to make payments. So despite the traditional requirement that I exemplified earlier, to exceed a non-contractual duty before it can constitute good consideration, Lord Denning very interestingly suggested in this case, Ward versus Bayham, that the mere performance of a public duty may sometimes constitute consideration. So again, let's look at the facts of the case. In this case, a mother promised to look after her child in return for what? Promise. In return for maintenance or income. And Lord Denning thought that there was consideration for the promise of the income, despite the fact that the mother was already under a statutory duty to look after her child. So the decision, on the face of it, it seems conflicting with, it seems that it conflicts with White versus Blewett, where natural love and affection of a parent was found insufficient for consideration. Now, it seems that public policy interest in a father keeping a promise to maintain his child may distinguish the case. The only difference between the two cases is that this public policy consideration, that a father's interest in keeping or maintaining his child. Another way to reconcile Lord Denning's approach with the cases discussed earlier is to say that promise simply to perform an existing public duty is sufficient consideration so long as enforcement of the promise is not contrary to public policy. So this is the only way to distinguish previous cases with this case, which is the exception of public policy. There is another case called Williams versus Williams. The facts of that case is that plaintiff left her husband and he agreed to pay her £1.10 per week. In return, she agreed not to pledge her husband's credit and not to indemnify him against any debts she incurred. And defendant refused to pay arrears, arguing that the plaintiff provided no consideration. And why? Because after leaving him, she was not entitled to be maintained by him or to pledge his credit. Again, the issue was there sufficient consideration? And it was held that plaintiff's promise was good consideration because she had only suspended her right to be maintained by defendant, as she could return at any time. And in this case as well, Lord Denning said a promise to perform an existing duty is sufficient consideration to support a promise so long as there is nothing in the transaction which is contrary to public interest. So again, if it is not against public policy, it can sometimes constitute as good consideration. So my question here is that why do you think that there must be a public policy exception if the performance of a public duty can constitute good consideration? Why should there be a public policy exception? What are the risks if this exception is not there? What are the dangers if this exception is not there? Yes. So Jennifer, yes, and Saliha. Jennifer is saying to encourage performance of certain public duties. Yes, of course, and that's right. And Saliha, that is interesting that Saliha is saying that it is for larger good. Actually, yes, that is absolutely right. public policy exception is there in place for larger good. And Yasha is saying there should be a bar to measure the least of consideration. Yasha, could you please explain it a little bit more? What you are saying? So, anyone else? Do you all agree with these answers? Okay. So basically, individuals, especially those in public office, they should not be able to extract, extra payment or extra money for doing or agreeing to do something that they are already obliged to do. So as a matter of public duty, and clearly there is a danger of corruption or extortion that they may perform in a manner which is more to the benefit of their private paymaster than for the public benefit. So like Saleha and Jennifer, they said that it is for the larger good, for public benefit. So that element is very important. And cases such as Collins versus Godefroy, it can be explained as examples of transactions potentially against public policy. The promise to, if you think that the promise to pay the witness was clearly, it was very close to the line separating an honest payment or a bribe. It could have easily been a bribe. How do you distinguish that it is just an honest payment and it is not a bribe to the witness to testify in your favor? So keeping the public benefit in mind, this exception is important. Okay. Let's move on. Okay. Another type of duty that we are going to discuss is an existing contractual duty owed to a third party. Okay. So if a person is under a contractual duty to act in a certain way, can the performance of that duty provide good consideration for a contract with another? What do you think? So if a person is under a contractual duty with one party, can the performance of that duty provide good consideration for a contract with a third party? Let's see. Okay, Raheen thinks yes. Okay, Sandeep, you are answering like a lawyer. Sandeep is saying depends. All those who are saying yes, okay, so Sandeep is saying that if there is an element in the contract that benefits the third party, then yes. Okay, so all those who are saying yes, why do you think so? Okay, so Femi is also saying depends if it is beneficial to third party. Right. So, okay, let's look at the facts of this case. The case here is Stockton versus Peg. And the facts of the case are that defendant promised to unload coal if plaintiff delivered it to him. The plaintiff was already obliged to deliver coal under a contract with a third party. And plaintiff sued the defendant for delay in unloading the coal. Okay, so the issue was was there good consideration in light of plaintiff's contract with a third party, and it was held that there was sufficient consideration. The case and this case provides the authority that performing an existing contractual duty can be consideration for another contract. Okay. Now let's look at another case on the same issue, and it will make things clearer to you, hopefully, and then I will also explain the whole thing by help of a diagram later on. So in another case, Shadewell versus Shadewell, the plaintiff was engaged to be married, and at that time period in 1860, this was a binding contract, and the defendant, the plaintiff's uncle, wrote to plaintiff that I'm glad to hear that you intend to marry Alan Nicole, and then he promised to assist him and to pay him £150 yearly to help him, start his newly married life. And the issue was the marriage good consideration? Despite the plaintiff having a contract with a third party, the plaintiff already had a contract with Nicole to marry her, and so was that marriage a good consideration for the contract between uncle and the nephew? And the majority found that plaintiff provided good consideration by marrying Alan Nicole. So this case is consistent with the case that we discussed earlier. And however, you need to keep in mind that marriage was potentially the consideration for uncle's promise in this case, Shadewell versus Shadewell, as this came before Section 1 of Law Reform Miscellaneous Provisions Act 1970. That act abolished the rule that marriage could be good consideration for a promise. So this case was before this act, and that's why it was considered a good consideration. Okay, so let's see a diagram that covers the same issue that we discussed in these two cases. So the issue is that P, if you look at the top of the diagram, P promises A £50 if he delivers petrol to X, right, a third party. Now A has already promised to do that for X. Can A's promise to perform his existing obligation to X count as consideration for P's promise to pay? Right? So P may be a customer of X, and P might be desperate for X to have some petrol, so therefore he is willing to pay A to perform his duty to X. So P is getting some kind of a benefit here. Do you agree? Okay, yeah. So if you look at A and X, they already have a contract. You see the lines between these two are solid. That means they have we are assuming they have a contract that that A is going to deliver petrol to X, right? But our issue here is whether A and P, do they have a contract here? Assuming that other elements of the contract are present, and the issue that we are looking here is consideration. Yes, they do, of course. And do you see what benefit P is getting here from A? Constance is saying, okay, yes. What about everybody else? Do you understand why it is a good consideration? A delivering petrol to X, although he was already under a contractual obligation to do that. But how does that benefit P? Yes. Okay. Sandeep is wondering. Okay. So Sandeep, if just think about if there is any benefit flowing from A to P. Yes. So you are absolutely right, Sandeep. The courts may look at whether that benefit is a legally sufficient consideration. Yes. So they will look at that. Mm-hmm. You got it? Okay. So the courts in these types of cases have actually decided that the benefit that P is getting, let's suppose X is P's customer, and P is P is desperate to get that petrol delivered to X. Okay. All right. So we agree that P is receiving a benefit, and courts have considered this kind of benefit as legally sufficient consideration. Agree? What about Carl? Carl, do you agree? Tammy? Okay, okay. So Tammy agrees, Carl agrees. Sandeep is still a little bit uh, somewhat agreeing and somewhat not agreeing. Okay, so there could be situations, Sandeep is asking, there could be situations where the benefit will not be there, right? If the benefit, let's assume if there is no benefit at all, then it doesn't seem right that P would request A to deliver something to uh, P would request A to deliver something to X if P did not have any benefit in it. Okay, all right. Yeah, so in most of the situations, there is a benefit in these kinds of situations. All right, let's move on. And you are welcome to discuss that in your next student discussion group, and you're welcome to write to me any questions that you have. Okay, so our next situation is performance of a contractual obligation already owed to the promisor. Okay, so we discussed that performance of a contractual obligation owed to a third party is a benefit. But what if the contractual obligation is owed to the promisor? So the general rule is that performance of an existing duty owed to the same promisor may not be good consideration. Okay. So let's see. Let me give you an example. I promise to, let's say, paint your wall, paint a wall in your house, and you promise to pay me 20 pounds in return. There is an obvious benefit here, right? And an obvious burden for each of our promises, and there is a clear exchange. Now imagine that I find the work much harder, and I originally thought that it would be a lot easier for me. It's just a wall that I need to paint, but later on I found out that it is really hard. And I promised to finish painting your wall, which remember I'm already under a contractual obligation to do that. So I promise to finish painting your wall if you make a fresh promise to pay me an extra 10 pounds. Now the question is, could I enforce your promise for the extra 10 pounds? You have to think that what have I given you in return for that promise? We all agree that when we made our first promise, there was a clear benefit and detriment. But for the next promise that I'm trying to enforce, is there any benefit that I have given you? No. Yeah. So a lot of you are saying no. Um, and that is the general rule here. And this general rule was derived from Stilk versus Myrick. And so the general rule, your general rule would be a promise to perform a contractual obligation already owed to another party will not constitute a good consideration. Very quickly, let's look at the facts of this case. So a plaintiff was a member of an 11-man crew on a ship, had a contract with the defendant who was a shipmaster, and the contract was to be paid £5 per month for working on a journey from London to Baltic and back. During the journey, 2 crew members deserted and no replacements could be found. The defendant promised the remaining crew members, including the plaintiff, an equal share of deserters' wages if they complete the journey. Now, again, keep in mind that that crew, or let's say the plaintiff, was already under an obligation to perform that duty to defendant. So the issue was there a good consideration? And the general rule applies here, which is the performance of an existing contractual duty owed to other party is not a good consideration for a promise of additional payment. It is very likely to see this kind of situation in an exam question. So I have seen it many times in an exam, and so it is an important thing you need to know and you need to grasp, and which is not very hard, I think. Okay, so however, very recently, it has been found that in certain circumstances, performance of an existing contractual duty owed to the third party may be consideration. Okay, so in this case, Williams versus Roffey Brothers, the Court of Appeal took a different approach. So while being at, they stressed that Stilk versus Myrick is not being overruled, but they nevertheless enforced Roffey Brothers' promise to pay an extra $10,300 if Williams finished the flats on time. Okay. So let's look at the facts of the case. Defendants were building contractors who had a contract to refurbish 27 flats, and there was a penalty clause for late completion. Now, pay close attention to this part of the fact that there was a penalty clause for late completion. So the defendants, they subcontracted the plaintiff to carry out the necessary carpentry work for £20,000. The plaintiff ran into some kind of financial difficulties, and they were only able to complete 9 flats. Okay, and they only did some preliminary work on the rest of the flats. And these difficulties were mainly or partially due to underestimating of the cost of the work, and also not managing it efficiently. The defendants were aware of the plaintiff's difficulties, right? And they promised to pay extra £10,300 at the rate of £575 per completed flat. Plaintiffs completed 8 more flats, but the defendant only paid them extra £1,500. And plaintiffs stopped working and sued defendants. Now, any idea what is the difference between the facts of this case and the case that we just discussed earlier? Okay, so there are lots of questions. Before I answer that, can you answer this question? Like, what is the difference between the facts? What is the difference between the facts of the case of Williams versus Roffey Brothers and Stilk versus Myrick. So here, let's go back to Stilk versus Myrick. It was an 11-man crew on a ship. Okay? So plaintiff is one of the crew members. So plaintiff who sued was one of the 11-man crew members. Okay? And during the journey, 2 crew members deserted. Right? So therefore, defendant promised the remaining crew members, including the plaintiff, an equal share of deserted wages if they completed the journey. If they completed the journey, they were already under the obligation to work during the whole journey. Okay, Ruheen is saying that in Rocky Brothers, a penalty is involved. Yasha is also saying a penalty is involved. Okay, penalty clause. So, okay, so that is the difference between the two cases. In William versus Rocky Brothers, there is a penalty clause. So by subcontracting the defendant, okay, and by paying them extra 10,300 to complete the work, they were supposed to avoid that penalty. So courts held that that was a good consideration, and the plaintiff. So what the court held was the plaintiff was only carrying out the work he was already contractually obliged to do. However, the defendants had obtained a benefit by making a promise, so it was enforceable, and the benefit was to avoid that penalty clause. Okay, and I see that there are. Okay, so Sandeep, you agree? Not encountering the penalty benefit. Yes, you are absolutely right. Okay, Andre, you're saying that William versus Rocky Brothers were also under obligation to complete. So the courts here found that they obtained a benefit in Williams versus Rocky Brothers because they avoided the penalty clause. So that is the main difference in this case. So despite the Williams promise only to do what he was already obliged to do, Rocky Brothers, in this case, in Rocky Brothers, it was stated that obtaining a practical benefit because they would avoid the penalty clause in their own contract with the housing association. And there was another more favorable payment scheme was put in place so that Williams was only paid per completed flat. So Glidewell thought that a practical benefit was sufficient, which in other words, legal consideration for a promise to pay extra so long as there was no economic duress or fraud. So as we discussed, that specific penalty clause was the main difference between this and Stilk versus Myrick. Okay, let me see the chat box and see what you guys are saying. Okay, Andre, okay, you got it. Jennifer, you seem to be disagreeing with the reasoning of this case. Let me see. Jennifer, would you Would you be willing to unmute yourself and speak about your concerns, like what you're concerned about? Okay, you understand it? All right. Okay, so basically in an exam question, if you encounter such facts, such a question, look for small details and see if there is any kind of a practical benefit involved. So if there is, then you can apply Williams versus Rocky Brothers. And of course, it would be a good, it would be good to argue both the sides because you can argue from the point of view of Stilk versus Myrick, right? And if there is any practical benefit involved, you might try to. You are welcome to try to apply Williams versus Rocky Brothers to the case, but it would be a good discussion in an exam question. So whatever you are discussing here in our chat box, this is all good discussion, and you are welcome to do that in your exam. Okay. So should we move on? Or do you have other questions about this? Okay. All right. So our next situation is involving past consideration. So it is not very difficult to remember the rule that past consideration is not good consideration from cases such as in front of you, McArdle. But it is very important to remember what past consideration means and why it is not good consideration. Okay. So past consideration refers to a time before the making of the promise. So you have to remember that. So in McArdle, the claimant had voluntarily carried out the improvements to the property 2 years before the unenforceable and effectively gratuitous promise to pay her for doing so. The fact that the promise said in consideration of you're carrying out the improvements did not turn the improvements into good consideration, as the improvements had already been made by the time the promise was made. So this past consideration refers to a time period before the promises were made. Let's look closely at the facts of the case. Plaintiff worked on improving and repairing a bungalow which had been left in trust to her husband and his 4 siblings. After the work was carried out, the siblings signed a document stating that executors should pay the plaintiff £488. Okay, so now here the improvements were done before any promises were exchanged. So issue was, could work carried out prior to the promise be valid consideration? And it was held that the promise was not binding. Okay, it was made after the consideration had been performed and before the promises were exchanged. Therefore, past consideration is no consideration. If you look at the diagram, this may make it clearer for you. We are going to use the same example that we used earlier. So the example was that you promised to pay me £50, and I, in return, promised to drive you to Oxford, right? So if I sue you for £50, once I have driven you to Oxford, then the consideration for your promise to pay me is executed, right? I have already performed the thing that I promised to do and conferred or incurred benefit or detriment, right? But it is not past. It is not in past, right? The contract was formed before I performed, so it was not in past. So the consideration is good. This is a good consideration. Okay. So look at the diagram. A contract is formed, a consideration is executed, then it is enforceable. Okay. So when a contract is formed, we exchange promises. Okay. After that, I drive you to Oxford as agreed, so I executed the consideration. And then I sue you for £50. That would be successful as this is a good consideration. Now look at the second scenario at the bottom and consider how the position differs if I just drive you to Oxford for free, and when we get there, you are very kind and you say that I promise to pay you £50 in return because you've driven me to Oxford. The benefit conferred by me, okay, is past consideration because I drove you before the promise was made. So therefore, I cannot sue you on your promise to pay me £50. Okay. At the very bottom of the diagram, again, see, first there is a past consideration, right? I drive you to Oxford. That is a past consideration. You conferred a benefit, and after that, promises are exchanged. You promise me that you are going to pay me £50. Okay. Now if I want to enforce it, I will not be successful. Now if I try to sue you for that £50, I will not be successful. Clear? Okay. Constance, yes. Jennifer, okay. Good. Okay, very quickly, let's look at a question. Carl is saying performance element is crucial for a contract coming into existence. And when performance element is crucial for a contract coming into existence, yes, and the time period when that consideration is or that performance is made. So if it is made before the exchange of promises, then it is a past consideration. It is not enforceable. But if it is done after the promises are exchanged, then it is a good consideration. All right, let's look at a question. So you have a question in front of you. Look at it, and then we'll discuss it. James leads an expedition to the Arctic Circle, where his team gets stuck. Fortunately, they stumble across another expedition which agrees to tow them back to safety in return for the rest of their provisions. Halfway towards safety, the rescuers demand that James' team also give up their fur jackets and other equipment once they are safe, or else they will be abandoned immediately. James reluctantly agrees, but then refuses to hand over the furs and equipment when safe. Are the rescuers contractually entitled to the furs and equipment? No. Okay. It is not enforceable. Okay, let's see. Absolutely right. Okay. So the rescuers were, as Jennifer said, that were already under an obligation to James to take his team to safety. So the promise to continue to take them to safety without any additional practical benefit would not constitute consideration for James' promise for the furs and equipment. So it would have been a different answer if there was an additional practical benefit involved. But there was no additional practical benefit involved here. And they were already under a duty, an obligation to do that. So no is the correct answer. Very good. Okay, the law of contract supports promises supported by a past consideration. It's very easy. False. Absolutely right. Why? Because past consideration cannot support a promise, like we just discussed, because it takes place before the contract is formed. It is therefore not possible that it was requested in return for the promise, and therefore there is no bargain to it. Okay. Another one. Performance of a contractual obligation owed to a blank constitutes good consideration for a promise. A contractual obligation owed to, Jennifer is saying third party, Sandeep, third party, third party. Okay. Right. Okay. And what is the, can you give me a reason for that? Benefit? Benefit to whom? Yes, the other party. Benefit to the third party involve, that is a separate contract. That is a separate contract. But benefit to, let me go back to that diagram very quickly. Here. Okay. So A and X, this X is a third party. Okay. So there is already a contract between A and X. Right? So the benefit under question is the benefit of P here in this diagram. Yes, Jennifer. Excellent. Because there is a practical benefit to the offering. Do you get it, Sandeep? All right. All right. Wonderful. Okay. And our cases for the third party, what are the cases for third party? Stockton versus Peg. Okay. Right? So a performance of a promise owed to the promisor will rarely constitute good consideration, and promisee must show that there is a practical benefit, as in Rocky Brothers. That is our case for a promise owed to the promisor, to the offerer. And the performance of a contractual duty owed to a third party will, however, constitute good consideration for a promise between promisee and promisor. Stockton versus Peg. That is, Stockton versus Peg is your case for third party contractual obligations owed to third party. William versus Rocky Brother is your case for, let me show it to you. Performance of a contractual obligation already owed to promisor, right? So that William versus Rocky Brother is the case for a contractual obligation owed to the promisor. For the third party is Stockton versus Peg. Already owed. Yes. Yes, Femi. Absolutely. So basically what I'm trying to say is that when a contractual obligation owed to the promisor, already owed to the promisor, comes under question, there is a debate on that. You can do a debate using Stilk versus Myrick and Rocky Brothers cases. But when the contractual obligation owed to a third party comes in, our case law is very clear there. We don't have many exceptions. Okay, and the case for that is Stockton versus Peg. Okay. One more. Performance of a pre-existing public duty. Select the best answer, and there may be more than one correct answers. So performance of a pre-existing public duty may constitute good consideration if the performing party exceeds his public duty. B, does not constitute good consideration if the performing party is only doing what he is already obliged to do. A and B. Okay, Yasha and Jennifer think it's A and B. Temi is saying A. Saliha is also saying A and B. Okay, so most of you are saying A and B. Excellent. Very good. So performance of a pre-existing public duty does not normally constitute good consideration for a promise. Collins versus Godefroy. Although Denning thought that it could in the Court of Appeal in Ward versus Bayham. Okay, the majority decided that case, however, on the basis that the mother had exceeded her public duty, as the police did in Glasscock Brothers versus Glamorgan, and so there could be consideration on that basis. So, if Lord Denning's approach were to be accepted, there would have to be safeguards to ensure that promises are not enforceable, where to do so would be against public policy. So this was just a refresher or a quick review of what we discussed about such cases. Okay, so that is the end of our lecture today, and thank you very much for your participation.